First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Okay, welcome to the First District Court of Appeal. We have one case on the docket today. It is C&S Wholesale Grocers versus the Florida Department of Business and Professional Regulation, case 22-3040. Counsel for the appellant, you may proceed when you're ready.
Good afternoon. May it please the court, Michael Bowen for the appellant, C&S Wholesale Grocers, Inc. We would like to reserve 4 minutes for rebuttal.
So noted.
The order of the trial court granting the department's motion for judgment on the pleadings must be reversed for the following 3 reasons. First, the trial court judge failed to follow the proper standard of review in this case. The dispositive motion filed by the department was a motion for judgment on the pleadings. This court has repeatedly instructed that the applicable standard of review asks whether the plaintiff has stated a cause of action in the complaint. This court has further explained that when passing on a motion for judgment on the pleadings, all well-pleaded material allegations of the complaint and all fair inferences drawn therefrom must be accepted as true. Not only is a recitation of this applicable standard of review wholly absent in the trial court order, but it is apparent that the trial court failed to apply the proper standard of review in this case. The second reason for reversal is that the well-pleaded allegations in the complaint and the fair inferences drawn therefrom make clear that C&S has made a viable cause of action under the Commerce Clause.
Counsel, let me ask you a question about that. The notion of discrimination in Commerce Clause cases assumes that the entities are substantially similar or they're competing against each other. Where in the complaint is there any allegation of those requirements for a Commerce Clause violation?
I believe it's paragraphs 23 and 24 of the complaint. We refer consistently through the complaint. There's a couple of different buckets. There's cigars, cigarettes, and then there's other tobacco products, or as constantly used by the department, OTP, it's called, other tobacco products. We refer to the 3 different classes together as tobacco products. At one point, we referred to them as non-cigar tobacco products, and the other as cigar tobacco products, and we refer to tobacco manufacturers. We lump all 3 categories together as tobacco products, meaning that they're fungible, one is the other, and they're all one class. And our position is that that factual allegation, in addition to any inferences that can be drawn from it, are that these all are the same tobacco products. They all compete with each other.
Well, but there's no allegation that the market of tobacco products is just one big market as opposed to cigars, cigarettes, and then the other tobacco products, snuff, and those kind of things.
Not specifically, Judge Bilbrey. There's no specific allegation that the market is the same, but our argument is that by alleging that they all are tobacco products, that they all compete with each other in the same market.
But didn't that allegation, as Judge Ray was asking, doesn't that need to be specifically stated that these are the substantially similar products in competition in the same market for you to state a cause of action under the Commerce Clause?
Our position is that under the standard of review, that you look at the express allegations and all fair inferences drawn therefrom. And we think that even if you were to take the position that it's that express allegation is not in the complaint, that the fair inference you can draw from the fact that we classify all tobacco products as one group as fungible, meaning that they all compete with each other.
But I mean, if we're looking outside the 4 corners of the complaint, couldn't we likewise then say, well, cigars are different than cigarettes, like the trial court found a rational basis for the distinction?
Under the required standard of review, you're not permitted to go outside the 4 corners of the complaint to make that conclusion. That is what the trial court did, and that's one of our objections to the trial court order, is that he accepted the department's factual statement that cigars and cigarettes are simply different. They're different products.
As far as the rational review on the equal protection claim, there's some Florida Supreme Court cases that even on a judgment on the pleadings appear to conduct that rational basis review, and we have some cases that do that too. I haven't seen any case that says, yes, you can conduct rational basis review on a judgment on the pleadings, or no, you can't conduct rational basis review. Is there any specific, besides just the rule on motion for judgment on the pleadings, is there any specific case you would like to direct us to that says you can't conduct rational basis review on a judgment on the pleadings?
I'm not aware of any case, but also I believe our position is I'm not sure it matters. And the reason why I say that is that it's clear under the either McKesson case from Florida Supreme Court or from U.S. Supreme Court precedent, at least it's the Western Life Insurance case, that states that economic protectionism defeats any equal protection defense, meaning that if you support your law by arguing that it's somehow protecting a local industry, that is sufficient in and of itself to invalidate the law, irrespective of the fact that there may be other legitimate reasons for having the law in place.
Did you need to allege that there's no rational basis for the distinction between cigars and other tobacco products?
Well, we allege there's a constitutional violation, so implicitly we take the position that there is no basis, there is no rational basis by arguing that there is a constitutional violation under the Equal Protection Clause.
So on the economic protectionism claim, paragraph 23 does, allege that the cigar manufacturing business is a large and important industry in Florida. But is that enough? I mean, there's no claim that it's unique, the industry is unique to Florida. There's no claim that the cigarette industry is not necessarily a large and important industry in Florida. I mean, so is that I question whether that allegation alone is enough to support your economic protectionism claim.
And could we have said it better? I'm not going to defend it and say that we surely could have. We could have easily amended potentially and made that express allegation, but we believe that on its face that allegation is enough. The fair inference drawn from that, in the event that the express allegation is not enough, supports the notion that cigar industry in Florida is very much protected industry. And we also allege, I believe, I forget which paragraph, that the legislative intent was to protect that industry, knowing that it is a favored industry in Florida. So I hope that addresses your question, Judge Ray.
But does there need to be some allegation that cigars are exclusively or primarily an in-state market, an in-state product, and cigarettes are exclusively or primarily an out-of-state market?
There does
come
not.
From an out-of-state.
There does not. There does not need to be that express allegation in the complaint. That during the context of the Commerce Clause argument, that needs to be one of the elements of proof, but we don't believe that needs to be alleged in the complaint.
Don't you have to state the elements to properly state a cause of action?
That's fair, although, let me back up. I want to make sure I understand your question. Are you asking whether we need to state in the complaint that the cigar industry is substantially in-state?
Correct, and that cigarettes are substantially out-of-state.
We believe in the same allegation that Judge Ray just read that is implicitly made. Maybe, again, it's not perfect, but we believe that it's implicitly made that we argue that Florida's cigar industry is Florida's cigar industry, then it's protected because it is a Florida cigar industry. But Judge Bilbrey, to your point, I think the McKesson case speaks to this issue directly. In the McKesson case, the Florida Supreme Court holding, not the U.S. Supreme Court reversal on another issue. On the McKesson case, the situation was the liquor industry that was being protected was Florida industry being protected, but it wasn't just Florida, meaning it wasn't just substantially a Florida industry. Manufacturers outside of Florida also made the same liquor that would have been protected. The issue in the case became one of whether or not that was enough, and the court determined that there was economic protectionism ultimately, that the liquor laws were put in place in that case to protect Florida's liquor industry, irrespective of the fact that other manufacturers outside the state could have made that same liquor and also benefited. But there are other cases as well that state that same line of reasoning from the U.S. Supreme Court, and it's notably the Washington Apple case.
If we disagree, what is the proper remedy? Should you be given an opportunity to amend your complaint to correct these errors, or at this point in the proceeding, what do we do about that?
That's a fair question, Judge Long, and debated that long and hard in my head. I think the answer to your question is we believe that on the merits, under the applicable standard of review that we should prevail. If this court were to determine it's not perfect, let's clean this up, and you have the authority to do this, sua sponte, you can direct the lower court with instruction to permit amendment to the complaint. and we could therefore amend the complaint to make the perfect allegations that would satisfy, hopefully, the department.
But you didn't ask leave to amend at the hearing and didn't ask for it in the motion for rehearing either. So is that even preserved for us to consider? Isn't it either all or nothing now?
That is fair. We back up. So as far as the history of this case, I can tell you with being complete honesty that we discussed amending the complaint before the department actually filed their motion for judgment on the pleadings. I spoke with counsel about our amendment of the complaint. It never happened because opposing counsel filed their motion for judgment on the pleadings. It was not raised in opposition to the department's motion on the pleadings. Fair. It was not raised in the initial brief here. It was raised in the reply brief where we cite two cases from the First District Court of Appeals, the Thompson case and the Adams case. In both of those instances, the court on its own directed the lower court with instruction to permit amendment to the complaint. Now, those cases were motions to dismiss, but motion to dismiss, for all intents and purposes, are tantamount to a decision, a motion for judgment on the pleadings. The elements that the court used in those cases to direct the lower court to permit amendment have nothing to do with whether the taxpayer raised it. The District Court of Appeals on its own determined that that was the right thing to do. So, Judge Long, that's a long-winded answer to get to your, hopefully, to satisfy your concern. Is that fair?
Counsel, there was discussion below at the hearing before Judge Cooper about whether this was a facial and as-applied challenge or just a facial. Why does that ultimately matter?
It matters a lot. I mean, if you argue that a constitutional violation is facial, you have to just stick to the words of the statute. I mean, does the statute on its face, and in this case that would be hard to do because you'd have to argue that the statute expressly intends for this Florida cigar industry to be protected. That's a hard argument to make. As applied, you apply to the facts of your particular case. And in our case, we could argue, look, we paid these taxes. We had to pay these taxes. We actually had to come out of pocket to pay these taxes, so we were harmed. And the cases that we cite, Bacchus, which is a U.S. Supreme Court case, one of the issues that came up in that case was one of standing on the issue whether the taxpayer can even raise an as-applied challenge. And the U.S. Supreme Court said, yes, you can. You were responsible for paying those taxes. So ultimately, you can raise it. To answer your question, Judge Ray, it makes a big difference at the end of the day. I've seen it entered my rebuttal time. Thank you.
You may proceed.
Thank you, Your Honors, and may it please the Court, Christopher Baum for the appellee. This Court should affirm the trial court's grant of judgment on the pleadings for the appellee on both of appellant's claims. First, turning to the Dormant Commerce Clause claim. The appellant fails on two different elements of that claim. As for their discriminatory effect claim, they have not sufficiently alleged that there are similarly situated entities that compete in the same market for the same customers. And DirecTV, the Florida Supreme Court case cited prominently in our brief, makes clear that the comparison is between entities, not between products. And there are no allegations at all about any entity at all, whether cigarette producer or cigar producer. So they have plainly failed to meet this element. And even if the relevant comparison were between the similarly situated products, they do not allege that cigars and cigarettes are fungible. That word appears nowhere in their complaint. They do not.
If you'll respond then to the argument that, well, perhaps the allegations are not perfectly drafted, there's reasonable inferences that can be drawn from them to support that element because of the broad, allegations of the constitutional claim at issue.
Sure, and I'll address that both as to the similarly situated and in-state versus out-of-state prongs. I don't think that there's any reasonable inference that could be drawn that cigars and cigarettes there are cigarette producers and cigar producers that are similarly situated entities. Because do we know whether they're different entities? Do we know whether these products are being produced by the same entity? Do we know where those entities are located? Do we know whether they compete in the same market? Even if the product even if you conclude that it's substantially similar, you don't know that it competes in the same market for the same customers. That's not fair.
So is all of that has to be pled? I mean, in many of the cases that both of you have cited, most of these kinds of issues are addressed through affidavits and evidence that's entered at summary judgment, but that didn't happen here. So do each of those specific things have to be addressed in the original pleading?
I think to satisfy either a motion to dismiss or a judgment on the pleadings, they have to allege specific facts that meet the elements of each particular claim. And even if you draw fair inferences from the allegations in their complaint here, you cannot conclude that there are facts in this complaint that support, that even go to this element. So, for example, you have to, for there to be a discriminatory effect claim, there has to be a different effect on in-state entities versus out-of-state entities. We don't know who the entities are. Who are the entities? Are they cigar producers? Are they cigarette producers? Are they in-state? Are they out-of-state? Is tobacco for cigars grown here in Florida? Are cigars even manufactured in Florida? Are they produced here in Florida? We don't know anything based on this complaint. There's no basis to conclude that.
Paragraph 23 says cigar manufacturing businesses are large and important industry in Florida. Is that not reasonable to at least infer from that an answer to many of the things you've just raised?
I don't think so, because does that mean manufacture? Does that mean rolling the cigars? Does that mean growing the tobacco for the cigars? There are no ultimate facts to support that allegation. It's a bare and conclusory statement, not supported by any fact other than counsel say so. And there's let me be clear, there's no allegation about cigarette producers. We have no way of concluding that cigarette production is not a large and important industry in Florida as well. We have no basis to conclude that cigar production is not a large and important industry in every other state in the union. So there's no way to conclude that there's any differential treatment of an in-state entity versus an out-of-state entity in this case, because there are no allegations about any entity. So for those reasons, we think that they fail to even come close to stating a claim of discriminatory effect. And we don't think that there's any case that they've cited that is remotely close to this case. So, for example, the Bacchus case, that relied on, there was a violation because the laws required either an in-state input, so a plant that went into the product, or in-state manufacture. Neither of those requirements are present here, obviously. Now, for the McKesson case, there was a tie specifically to Florida. So, for example, there was a tax preference for a particular liquor that was made out of products that could be grown in Florida. But there's nothing like that here. There is no discrimination based on the location of a cigar or a cigarette where it's produced. It could come from anywhere, and if it's a cigar, it's not taxed. It could come from anywhere, and if it's a cigarette, it is taxed.
What about the discriminatory purpose or intent? I mean, DirecTV is pretty clear on the elements for the discriminatory effect, but where do we look to find those for the discriminatory intent?
Sure. So DirecTV is also directly on point there, and it says to look to figure out whether there's a discriminatory purpose, you look to the text and you look to the legislative history. Now here, Appellant doesn't dispute that there's nothing in the text that is facially discriminatory or indicates any discriminatory purpose. And they have not pointed to anything in the legislative history that evinces any type of discriminatory intent. And in fact, the only legislative history that we were able to uncover discloses that the differential treatment related to the different health effects and Medicaid costs related to the different products.
Is that something that they would have needed to allege, that, you know, Senator so-and-so from Tampa
Sure.
happened to say this about the tax, this is going to help my industry and really going to kill the cigars?
Absolutely.
Cigarettes, rather.
Absolutely.
They
There's
would
something
need
in a
to allege
committee
that?
report. I'm sorry, Your Honor.
I'm sorry, they would need to allege that, is what you're saying?
Absolutely, because we're taking all of their facts stated in their complaint as true and saying, even if all of that is true, you have not stated a claim. And they have not, because they have not pointed to anything in the text or legislative history, and they say, well, you know, maybe we should have been allowed to have discovery on this. Well, what discovery are you going to have into legislative history in this context that would be relevant? Why can't you simply go look at the legislative history and tell us what it says? Because there's nothing in there that remotely points to any sort of discriminatory intent. So unless Your Honors have any further questions on the Dormant Commerce Clause claim, I'll turn to the Equal Protection claim. This Court's decisions in Valleycrest, in Hameroff, and in People Against Section 561 all make clear that the standard applicable to this case is rational basis review. And I urge you, in case you haven't done so recently, to go back and read Valley Crest, because it makes this very clear that the state can tax seemingly identical items with near impunity.
Well, Valley Crest, and you cite that a lot, but that was on a summary judgment motion, right? So,
That's right, Your Honor, but we don't think that there's any material difference there, because at summary judgment, there's no genuine dispute of fact as to the facts that the parties are saying, and they're saying, take those facts as true. Is there a cause of action that has been?
But whether a statute has a rational basis or not, is that a fact issue, or is that something that can be determined in a judgment on the pleadings or motion to dismiss?
I think it certainly can be determined at a motion to dismiss stage or a judgment on the pleadings. And in fact, this court in the Barnes case was reviewing a judgment on the pleadings on an equal protection claim. It reviewed that de novo, applied rational basis review, and affirmed.
And I'll ask you a similar question to ask your opposition. Are you aware of any case that says you can do that on a motion for judgment on the pleadings? That it's, I mean, I know there are cases where it was done, where we've done it, where the Supreme Court has done it. Has anybody ever said on a judgment on the pleadings it is appropriate to conduct a rational basis review?
Barnes is the closest case that we've been able to find, and so that's what we cited for you. But I don't think that there's any question that it can be done, because the question at rational basis review is whether the state can come up with any conceivable basis to support the differential tax treatment here. The burden is on the plaintiff to show that there's no conceivable basis. And that's not a fact question, because it doesn't matter if the purpose was true, or it doesn't matter if it was the legislature's purpose. It's if the court can even think of a rational purpose to underlie the law.
Do you contend that that needed to be pleaded as an element of the equal protection violation?
I think so, but even if it didn't, we would win as an affirmative defense, essentially, because we have brought forth the conceivable bases that would support this law under rational basis review. And those bases are that, for example, as the trial court discussed, perhaps there are differing health implications based on cigarettes and cigars. Perhaps there are differing addiction implications based on cigarettes and cigars. Perhaps there are differing numbers of people who use each product. Any one of those could be a rational basis for the legislature to have chosen to tax these differently. And so I don't believe that there's any difference between applying the rational basis review standard at summary judgment stage or at the judgment on the pleading stage, because either way you're taking a set of facts and you're saying there's no dispute over this set of facts, and you take that set of facts, have they sufficiently met the cause of action? And here they plainly have not. Now, turning to their counter argument, they say, well, any whiff of economic protection automatically invalidates any statute, even if there's some other purpose that would be sufficient. But that's not what the Supreme Court cases say at all. In the Western and Southern case, in the Ward case. So the Ward case, for example, there was an equal protection challenge to a facially discriminatory tax regime. And the state defended it, saying, well, the heightened standard of review that applies when there's a facially discriminatory tax is whether there's a legitimate state purpose. We think it's a legitimate state purpose that it's just economic protectionism. We're protecting our in-state businesses. The Supreme Court said, no, that's not good enough. That's not a legitimate state purpose. But two things. That was a heightened standard of review because it was a facially discriminatory tax. But also, the Supreme Court did not invalidate the statute for the state having to assert economic protectionism. It remanded and said, well, the state has asserted 15 other purposes. Go back and figure out whether those purposes support this law. So their contention that economic protectionism somehow is just totally fatal to any law is just wrong. So for all these reasons, their equal protection clause claim fails because rational basis review applies, and there are plenty of conceivable bases to support this law. Now,
let me take you back for a second to the first argument that they present, that the trial court's relying on matters outside the pleadings. So the trial court I think at least somewhat significantly relies on a finding that cigars and cigarettes and other tobacco products are dissimilar. Can the trial court make a finding that they're dissimilar at this stage with these pleadings and then enter a ruling in your favor?
Frankly, I don't think it matters, Your Honor, because this court's review is de novo. So whether the trial court relied on something outside of the pleadings or not, we still win because this court, not relying on anything outside of the pleadings, would easily be able to conclude that we have met our burden as under the judgment on the pleading standard. So whether the trial court relied on something outside of the record or not is irrelevant to this court's review at the de novo stage.
Do you think it matters, at least for affirmance for us, whether or not they're dissimilar?
I think the inquiry in DirecTV is whether the entities are similarly situated. I don't think it matters. I don't think you need to conclude that cigarettes and cigars are dissimilar. I think you can conclude that they are substantially similar. It doesn't matter. The relevant inquiry under DirecTV is whether the entities are similarly situated and competing in the same market for the same customers. Now, turning to Your Honor's previous question about amendment, they shouldn't be allowed to amend for at least 3 reasons. First, they first raised it in their reply brief, and I could cite you a bunch of first district decisions saying you can't raise things for the first time in your reply brief. Second, they did not, as Your Honor pointed out, ask for leave to amend below, and had their argument not been in their reply brief, I could have pointed you to a bunch of cases that say you cannot raise the issue of amendment in the Court of Appeals when you have not moved for leave to amend below. But third, if you're affirming the judgment here, it would be passing strange to allow them to amend their complaint when there's a judgment against them on these claims, because certainly there would be res judicata implications. This is not a case where you would be saying, well, you know, the motion to dismiss was properly granted, but it shouldn't have been with prejudice. They should have been allowed leave to amend. This is a case where there's a judgment. So if you affirm the judgment, you can't allow them to amend. And so for all these reasons, even if you think that, you know, the preservation issues are no bar, they should not be allowed to amend on remand. If Your Honors have any further questions, we would ask this Court to affirm.
Okay, thank you.
The takeaway that I have from the department's argument is that our complaint needed to read like a treatise, apparently. We needed to cite every specific entity that in Florida that manufactures cigars that potentially benefits, every manufacturer of cigarettes that potentially is out of state who's at a detriment as a result of these laws. We have to cite all the legislatures who may have spoken against taxation of cigars. That seems like a lot. I think ultimately the standard for notice pleading here is sufficient in the sense that we've alleged the relevant elements of both the Commerce Clause claim and the Equal Protection claim. Under the Commerce Clause claim, we have alleged, whether expressly or drawn through inferences, that substantially similar products are competing in the same market. Now, the department has argued that we need to name entities. I'm not aware of any precedent, whether Florida or U.S. Supreme Court, which restricts the analysis only to entities. They compare products. Whether that's the McKesson case comparing liquor products, whether that's the Washington Apple case comparing crates of apples, whatever the case may be, Bacchus comparing liquor, I mean, whatever the case may be, they're not comparing manufacturers, they're comparing products because the tax is on the products, ultimately.
Yeah, well, so the language used in DirecTV is entities. I looked back and checked on that, and of course they focus in part on the services the entities are provided, but that certainly is the language. Could you talk about why that language was not appropriate here?
And I'm not aware of the exact page in that, but I believe we cite it in our brief that it does refer to entities, but it uses entities by reference to their products. It compares the products. So yeah, it is shorthand to say entities, but ultimately it's only the products that are being made that are being compared for the purposes of constitutional analysis.
How do we infer that cigars and cigarettes are substantially similar products?
That's something to be decided on discovery. And ultimately, in this
you didn't specifically allege that, so you're asking us to have the reasonable inferences from your complaint, which you're entitled to get on a motion for judgment on the pleadings, but you're asking us then to infer that they're substantially similar. How do we do that?
Well, we assert through the express or the inferred allegation that they are similar. That has to be taken at face value for the purposes of the standard of review. It's not, I don't believe it's, I don't mean to contradict you, Judge Bilbrey, but I don't believe it's your position, much like it wasn't the trial court's decision to say, look, they're just different products. I make that factual finding, as Judge Long indicated. I don't think that was the right decision to make. Ultimately, that's a factual decision to conclusion that was made outside the four corners of the document.
Had you said these are different products, then I think that argument might have more validity than when you don't say whether they're similar or dissimilar, and you're asking us to infer that they're similar. Isn't that the same problem as the judge saying that they're dissimilar?
Well, we allege that they're similar, and we should be.
Where do you allege they're similar?
Because we refer to the whole grouping as tobacco products. We refer to cigars as cigar tobacco products. We refer to cigarettes as, again, with other tobacco products and cigars as tobacco products. We refer to all of them as one fungible group within the document. So we refer to them as being substantially similar in that context. And that should be our ability to prove on discovery in this case, which we have not been afforded the right. Although we have served discovery in this case on the docket, it has not been responded to because of the motion for judgment on the pleadings. If there are no further questions, we would request that this court respectfully reverse the order of the trial court judge. Thank you.
Thank you, counsel. Thank you to both attorneys that were presenting today. The court will now be adjourned.
All rise.